Hello and welcome to Topic 8, Lecture 2. And in this lecture, we're going to be learning about the Supreme Court and judicial review. Okay, so what are we going to cover in this lecture? Well, first we're going to take a look at the United States Constitution and what it says about the federal judiciary. Then we're going to take a look at the Supreme Court, how the Supreme Court members are selected and what their session is. We're going to look at the Supreme Court process. In other words, how the Supreme Court decides to hear cases. We're going to look at the Roberts Court so you get an understanding of who's sitting on the Roberts Court. And then we're going to spend time learning about the major power of the Supreme Court, which is the power of judicial review. So let's get started. So the federal judiciary is established by the United States Supreme Court. The lawmaking branch, Congress, is established by Article 1. The presidency is established by Article 2. And the federal judiciary is established by Article 3. And in Article 3, Section 1, it's there where we find that there is in fact going to be a Supreme Court. It reads that judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. Okay? And so that's what that's not all the Constitution tells us about the Supreme Court, but that's the phrasing in Section 1 where we know that there's going to be a Supreme Court. In Article 3, it also tells us that the types of cases that the Supreme Court is going to hear, and we know that the types of cases that the Supreme Court here must deal with some aspect of federal law or the Constitution, okay? So if there are cases that are dealing only with state law and have nothing to do with federal law or the federal U.S. Constitution, the Supreme Court doesn't have jurisdiction to hear that case. Cases must be somehow linked to federal law or the Constitution. In terms of the type of court it is, that for the most part, the Supreme Court of the United States is an appellate court. It doesn't hear cases for the first time. It hears them on review. However, in Article 3, it does say that there are certain kinds of cases that the Supreme Court can hear for the first time. In other words, there is some original jurisdiction, the ability to hear a case for the first time, that is granted to the Supreme Court. And so, the types of cases that the Supreme Court can hear for the first time, has to do with if there's a case where there's a dispute between one state and another state. That it can also deal with cases that involve like foreign ambassadors or ministers that are, in the United States. And it can also be cases where a state brings a suit against a citizen. Okay, so all of those sort of allow the Supreme Court to hear a case for the first time. The Supreme Court rarely hears cases for the first time. I think the last one that I can remember was about, almost 30 years ago. And that was a case where there was a dispute over Ellis Island and who owned the land that was where the Statue of Liberty is. Who owned that land? Was that New Jersey's land or was that New York's land? And you think it'd be New York because it's like the Statue of Liberty seems to be like associated with New York. But the Supreme Court in that dispute actually determined that the land, that most of it underwater was on the New Jersey side. So that's an example of the court's exercising of original jurisdiction. But almost 100% of the cases that the Supreme Court here are on review. The size of the Supreme Court is not set by the Constitution. In the Constitution, it says there will be, one Chief Justice and 8 associate justices. It's not mentioned. And so the size is not set by the Constitution, but that power is given to Congress. And the size of the Supreme Court has changed over time, that the Congress can change federal law to either increase or decrease the number of justices that serve. It's varied over time, but it's been 9 since 1869 that there's 1 Chief Justice and 8 associate justices for a total of 9. And if you might have been following the news recently as a response to sort of this sense that maybe the Supreme Court is not representative of the viewpoints of the majority of Americans, right? That whether that's a true statement or not, some people think that's true, and there's been some movement in the United States for Congress to actually increase the number of justices that serve on the Supreme Court. Well, whether or not that happens, we'll see. But you should just keep in mind that that is a power that is constitutionally granted to the Congress. Another power that Congress has as it relates to the federal judiciary is that the Congress establishes the inferior federal courts. And so while the Constitution says that there will be a Supreme Court and tells us what the powers of the Supreme Court are, that how many trial federal courts we're going to have or how many appellate courts, intermediate appellate courts we're going to have, that decision making is left to the Congress. And in fact, that's the types of cases that courts can hear. That's a power that's also left to the Congress. And so the U.S. District Courts and the U.S. Court of Appeals, those are created by Congress, and that the number of those has changed over time. And we're going to see that is the case when we get to our case that we're going to be discussing in this lecture, Marbury versus Madison. The Constitution also tells us how the Supreme Court justices and other federal justices are selected and give us an idea of what their term of service is. So all federal judges, whether they serve on the Supreme Court or whether they serve in the lower level U.S. district courts or the Circuit Court of Appeals, all of those judges, and there are hundreds of them, okay, most of the attention is on the nominations of the Supreme Court justices, but there are many justices in the federal courts, and all of those justices are nominated by the President of the United States and confirmed by the United States Senate. So whenever there is a vacancy on any of the federal courts, the president that is in power at that time nominates who they would like to be the replacement for the vacancy. And then the U.S. Senate exercises its advice and consent power, and they basically confirm the justice, or they could decide not to confirm that justice. That doesn't happen very frequently, although that it has happened. The most recent of these confirmations is the newest member to the Supreme Court, Associate Justice Ketanji Brown Jackson, and she's pictured here just above me. Her judiciary confirmations took place in 2022, just a few months ago. And in this picture, you can see just barely two of the members of the Senate Judiciary Committee. This is Dick Durbin from Illinois and Chuck Grassley from Iowa. And they both are on that committee. And so they were a part of the questioning that went on during her confirmation process. Once any federal judge is confirmed by the Senate, then they are sworn into the federal court, and they serve a lifetime appointment, okay? That our framers wanted to make sure that obviously the justices were not subject to elections. Now, state justices can be subject to elections, as is the case for all of the justices that serve in Wisconsin. They all are elected and also have, in some cases, they have clear terms before their, next election. But that's not the case with the federal judges. Once they are appointed and nominated and confirmed, that they serve for the course of their life. And however, that they can be removed through impeachment. So that was a check that the framers put in. But the framers didn't want the Supreme Court or any of the federal courts to be subject to politics, right? Now, I teach civil liberties, so I'm well aware of the fact that politics plays a role and ideology plays a role in the decision-making of the federal courts. However, the framers wanted to have the federal judiciary be insulated from that kind of politics, even though it's an ideal, but that ideal is rarely realized. There are no constitutional qualifications to serve as a federal justice, so I guess, somebody could be without any qualifications would serve. But the thinking is a president would never do that, and a Senate would never confirm such a justice. So there's a check. You don't need the thinking among the framers was you didn't need to write down the qualifications, right? Because they trusted the president and the Senate to look out for the good of the country and only nominate and confirm those justices that were in fact qualified. For the Supreme Court, most of the justices have served in the lower federal courts and have worked their way up. They usually go to the top law schools in the United States, as was the case with Ketanji Brown Jackson. She went to Harvard Law and she served on the Circuit Court of Appeals. And so most of the justices have, excellent experience to serve. The Supreme Court session, this isn't in the Constitution, but this is just the protocol that is followed, that the Supreme Court session starts on the first Monday of every October, and then it ends somewhere towards the end of June, sometimes going into July, but not very frequently, although during pandemic it did for reasons because of pandemic. And so we are at the start of a new Supreme Court session, because here we are right at the end of October. And so keep your eyes open for some of the activities that are going on. This term, the Supreme Court has already heard cases on the Voting Rights Act. Today, they're hearing cases or as I'm taping this, on affirmative action. And later on, they're going to be hearing oral arguments on a case that we read about earlier in the semester, the case about 303 Creative LLC, the computer company that didn't want to make websites for same-sex marriages. So keep your eyes open for that. And as it says there, the first Monday of October until the end of June. And if you're interested, there's a great book that you could read about the Supreme Court and really kind of the inner workings of the Supreme Court and learning about the justices, but then also some of the major controversies that have gone on within the Supreme Court, the kinds of cases that they've heard. And it's called The Most Dangerous Branch. We read it in my civil liberties class, but it's a fun read. If you want to pick it up, I encourage you to do so. So who are the 9 justices that currently serve on the Supreme Court? Well, here's a picture of them. Every court is named after, or court sort of era, is named after the Chief Justice of the Supreme Court. And the Chief Justice right now is Chief Justice John Roberts. And every time a new member of the court joins the Supreme Court, they take a class photo, right? Or a photo of the members of the court. And recently there was this great article, and I'll put a link to that in where underneath where the lectures are this week, about the long history of taking photographs of those who have sat on the Supreme Court. And as many of you might know, photography, it goes back before the Civil War, right? And so we have a photo chronology of all the members who've sat on the Supreme Court, and the New York Times, published all of those, and it kind of gave some backgrounds about the photos themselves. But sitting in the middle of the photos is always the Chief Justice. And so this is Chief Justice John Roberts. He was appointed in 2005 nominated in 2005 by George W. Bush. And he has been the Chief Justice ever since. He wasn't on the court. He was an appellate justice in the circuit court. And so he was just nominated to serve on the Supreme Court as the Chief Justice. And they call this, the Roberts Court. It started in 2005. Prior to that was the Rehnquist Court, because the Chief Justice was William Rehnquist, a native of Whitefish Bay, Wisconsin. He was an Associate Justice before he was elevated to serve as the Chief Justice of the Supreme Court. Some of the famous eras are the Earl Warren Court, when a lot of individual rights were expanded. The Rehnquist Court is known for ushering in sort of a more conservative court, and that's continued the conservative aspect aspect of the court has continued with the Roberts Court. And right now we probably have the most conservative court that we've had in a while in the United States. So the Chief Justice sits in the middle, and then that on each side it goes by seniority. And so we've got Clarence Thomas here, Sam Alito here, Sonia Sotomayor here, and Elena Kagan. These are the most senior justices, starting with Clarence Thomas, seniority in terms of how long they've been on the court. In the back are the least senior, okay? And so the least senior are Neil Gorsuch. He was appointed by President Trump, or nominated by President Trump. Brett Kavanaugh, Amy Coney Barrett, and the most recent addition, which is Ketanji Brown Jackson. On this slide, it gives you a little bit more information about the judges, okay? And so it starts with the Chief Justice at the top here, and then it goes down by seniority, and we were just talking about that. So Ketanji Brown being the least senior justice. That, as I understand it, that the newest addition to the court is the one who gets the other members' coffees during conference time. And so maybe Amy Coney Barrett's sort of happy that she doesn't have to do it anymore. She's passed the baton on to Ketanji Brown Jackson. So it shows you the names. It shows you how old they are. And so the oldest justice is Clarence Thomas. Just because you're older doesn't mean you're the most senior. The seniority is ranked on time served, but he is both the oldest and, the Chief Justice has the highest level of seniority. But in terms of the associate justices, next is Clarence Thomas. It shows you about their experience. As I mentioned, that the vast majority of them served in a capacity as a circuit appellate justice on the federal courts. The exception here is Elena Kagan. She served as Solicitor General prior to being elevated to the Supreme Court. That is the top lawyer for the United States, the Solicitor General. And then it also shows you Yale and Harvard, and also their religions. I put the religions there because the dominant religion in the United States has always been Protestantism, with Catholicism kind of coming in second. And that's still true today, but the court is really dominated by many Catholics. And prior to the addition of Neil Gorsuch, there were only Jewish members of the court and Catholic members of the court, which was, odd because there were no Protestant members of the court, even though that is the religion that has the most adherents in the United States. But with the addition of Neil Gorsuch and now Ketanji Brown Jackson, who is not a denominational Protestant, that we have some Protestant additions to the court. And then it shows you here that the presidents who nominated, and I was talking about how conservative the court is, and right now there are only 3 justices who have been nominated by Democratic presidents. And so we have Sonia Sotomayor, Elena Kagan, and Joe Biden, who nominated Ketanji Brown. The rest, Trump nominated and was able to confirm 3 justices: Gorsuch, Kavanaugh, and Amy Coney Barrett. And then George W. Bush and his father, George H.W. Bush, nominated Clarence Thomas. So that helps us get an understanding of the conservative leanings of the Supreme Court. However, just because you are nominated by a Democratic or a Republican president doesn't necessarily mean that you are going to rule that way. But just as the United States has become more polarized in terms of ideology and party affiliation, so too has the court. It's kind of a reflection of the general political atmosphere in the United States. Now, we're going to take a look now at the process of the Supreme Court. Like I said, you're going to learn a lot more about how a case gets heard by the Supreme Court in the textbook, but also in the Vox video. But I thought I'd just give a quick overview here as well. The first thing I want to point out is that you don't have a right to have your court reviewed by the Supreme Court, the court of last resort. The Supreme Court has discretion as to whether or not it will hear a case. And as you'll see in the Vox video, less than 1% of the cases that people ask, "Hey, Supreme Court, please review my case for the last time," they only grant review to a handful of cases. about 80, even sometimes less than 80, which is less than 1% of the cases that have asked for review. And so there, that while you can ask the Supreme Court to review your case, the chances of it actually getting reviewed by the Supreme Court are very slim. The process of asking the Supreme Court to hear your case is that you fill out a writ. It's sort of like a form. It's a legal document where you are basically legally asking the Supreme Court to hear your case for final review. And it's what is known as a writ of certiorari. That's what that request is. Hey, Supreme Court, read my writ of certiorari and say, yes, grant me a writ of certiorari. Say yes to my writ so that you'll review my case. And so there's a formal process for the court to decide whether or not it wants to hear your case, in other words, to pick it up for final review. Now, if you ask the Supreme Court to review your case and the Supreme Court says no, you might be wondering what happens, right? Does that court case disappear? No. It's the decision of the lower appellate court that stands. So if the lower appellate court rules and says that this law is constitutional, and then one of the parties of the case says, no, this law is not constitutional, please, Supreme Court, review this and hear this for a final time. If the Supreme Court says, nope, we're not going to grant you a writ of certiorari, then the ruling of the lower appellate court stands. Okay? If cert is granted, okay, so if you're one of the lucky less than 1% where you are granted a writ of certiorari, or for short, just writ of cert, that lawyers for each side, they fill out written briefs, okay, and making a case for why the justices should rule that this law is constitutional, or making a case for why the Supreme Court should say, no, this law is unconstitutional. So basically, the briefs are written arguments that are being presented to the courts. And other parties can also, if they are recognized as having the authority to submit what's known as a friend of the court brief, an amicus curiae brief to the court. Third parties will say, hey, it's not just the lawyers that are submitting these briefs, but third parties will submit these briefs as well, trying to add on to the persuasiveness of either finding the law constitutional or unconstitutional. And so after the briefs have been submitted, the date for oral arguments is set. And that's, what happened today with the oral arguments in the affirmative action cases. And generally, when the court hears the arguments, each side gets 30 minutes to make their case. Today they went longer, so the court also has the power to extend the length of the oral arguments. And you can listen to those arguments. They are now broadcast in real time. So this morning on the Times, I just turned on the New York Times and I was listening to the oral arguments. I didn't listen to all of them, but they're also archived and you can listen to them as well. And they're not hard to understand. I mean, sometimes students get kind of freaked out about the Supreme Court. They're like, oh my God, I'll never understand it. It's all this legalism. Some of it is difficult to understand. But for the most part, they're really just speaking in plain English. Basically, the lawyers ask questions, and the Supreme Court sort of, members, basically challenge them on some of their claims. So it's really cool. And if you get an opportunity, take a listen to it. After oral arguments, then the court decides how it will rule, and there's a whole process for how that takes place. So make sure you read about it in the textbook. And so basically, they have a conference and they go around and they vote on how they would rule in this case. And then if the majority, the Chief Justice will designate who will write the decision if the Chief Justice is in the majority. And if the Chief Justice isn't in the majority, the most senior member that's in the majority will appoint the author of the decision. And so a decision of the court is written, and then there are also opinions that are known as concurring opinions that agree with the decision of the court, but maybe for different reasons. Or there are dissenting opinions where they're like, nope, the court was wrong. I disagree with the decision of the majority, and here's why. And so you have a majority opinion, dissenting opinions, and concurring opinion. And once the court rules, the decision is final. It becomes precedent, right? And it's supposed to be used for guiding other court decisions. As we know, that's not always the case. For one, that you could get a new court and a new ruling, and so precedent is overturned. Examples of like landmark precedent overrulings was Plessy versus Ferguson that said, hey, separate accommodations for Black and white people don't violate the Equal Protection Clause. Separate and equal is constitutional. Well, that precedent was overturned in 1954 by Brown versus the Board of Education that said, no, separate but separate schools for Black and white children is unconstitutional. And as we know, just recently, Roe V Wade, that was decided in 1973, that said that people who could get pregnant had a constitutional right to an abortion. The court just recently overturned that precedent. And so precedents the decisions of the court aren't final. They could be new court, new ruling. Also, you could amend the Constitution, and that the amendments of the Constitution trump the decisions of the court because they become a part of the Constitution. So one of the major powers of the Supreme Court of the United States is what is known as the power of judicial review. Okay. And so as it says there, one of the most important powers of the Supreme Court is the power of judicial review. What is judicial review? Judicial review is the power that the Supreme Court has to invalidate actions of Congress, of the executive branch, or the actions of states if these actions are deemed unconstitutional. Okay. And so basically, today with the affirmative action cases, the question is, a state actor, state schools, the University of North Carolina, they get federal funds, right? They're subject to the Constitution, and they're saying, hey, they have this process. They're taking this action that takes race into consideration when it comes to college admissions. Is that constitutional is the question. And if the Supreme Court, it looks like they're likely to say that that's not constitutional, right? That then they invalidate that practice. They basically say you can't engage in that practice, University of North Carolina, because it is unconstitutional. And that is the power of judicial review. Roe v. Wade, good example, right? Roe v. Wade said that you have a constitutional right to an abortion, and that invalidated all the laws that were on the book that criminalized abortion, okay? And so that's an example of the exercising of judicial review. Judicial review is not in the Constitution. It is an implied power. It is a power that is derived and established by, it's established by the decision in Marbury versus Madison, which we're going to talk about in a moment. And so basically the Supreme Court determined what one of its major powers was, this power to invalidate the decisions, the unconstitutional laws. Because the thinking was that we have a law and it violates the Constitution, but we let that law be the law of the land, it kind of makes a mockery of the Constitution, right? And so the Chief Justice at the time of Marbury versus Madison, John Marshall, probably one of the greatest Chief Justices in Supreme Court history, maybe Earl Warren comes in second, I'm not sure. But John Marshall, wrote the majority opinion in Marbury versus Madison that established this power. Now, you might be asking yourself, Professor Hankinson, what the heck are you doing here with this photograph right above your head of that duck? And it's got this lame, it's got a cast on its foot. It's got some sort of like brace on its foot. What the heck is going on there? Well, it's up there because the case of Marbury versus Madison stems from the lame duck Federalists, which we'll talk about a moment. in a moment. And their desire to pack the courts with Federalists before they got kicked out of office. They were lame ducks, right? A lame duck is that you have an election and then they say, bye-bye, Federalists. And then the Federalists are like, well, before we're actually kicked out of office officially, we're going to change a bunch of laws because we don't have a consequence anymore because we've already lost the election, right? Well, let's take a look at the case Marbury versus Madison. It's a fun case, and we'll talk about its relevance for judicial review. All right, so let's learn about the case Marbury versus Madison and what this case is about and the political conditions from which this case stems from. So when the United States was first founded and, when the Constitution was ratified in 1789, political parties didn't exist. And in fact, when the Constitution was created, the framers were really worried about political parties. They viewed political parties as factions and being very dangerous. And so for the first, 4+ years after the ratification of the Constitution, there weren't political parties, right? However, halfway through, so George Washington, our first president, he served for 2 terms, a total of 8 years. And during the course of his presidency, political parties started to form. And so the George Washington, and as you see here, that is John Adams, okay? And then Alexander Hamilton. And if you've watched Hamilton, the musical, you might be familiar with the battle between the Federalist Party and the Democratic Republicans that was created by Thomas Jefferson. In the 1790s, we see that political parties begin to form. And so even though Thomas Jefferson is a part of Washington's cabinet, he's the first Secretary of State, that he begins really differing with the political values of George Washington, John Adams, and Alexander Hamilton. So Thomas Jefferson and James Madison form a new party. That new party is known as the Democratic Republican Party. And from an ideological perspective, it's really different from the Federalist Party. And so Thomas Jefferson challenged John Adams in the election of 1796. He was a Democratic Republican, and he wanted to challenge John Adams when he ran for president. And Thomas Jefferson lost. The Federalist Party won. But Thomas Jefferson, he wanted the Democratic Republicans to succeed. So in the election of 1800, he challenged John Adams again, and this time the Democratic Republican presidential nominee won, Thomas Jefferson. And the election of 1800 was really bitter. And I'll post like a campaign ad that's based on some of the things that John Adams and Thomas Jefferson said to each other to sort of show that campaigns then were oftentimes just as vicious as they are now. So the Federalist Party was ousted. Okay. However, just like it is today, we have an election in November. Okay. But then the new president doesn't come in until January, right? It was the same there. It wasn't January. It was in March, but still there was this period of time where the Federalists were still in power, but not only was there going to be a Democratic Republican president with Thomas Jefferson, but all Congress was changing hands too. Congress, prior to the election of 1800, was in the hands of the Federalists. But John Adams lost his job, and so did many of the members of Congress. And so we're going to have, coming in 1801, it was going to be the Democratic Republican president and a Democratically Republican held Congress. And so John Adams, the Federalists were pissed off about this, right? That they are basically lost their jobs. But they were lame ducks, okay? And so up there, the lame ducks. And so basically the Federalists said, you know what? We might have lost a presidency. We might have lost Congress, but we can still do pass some laws that's going to increase the power of the Federalist Party. That's exactly what they did. They passed the Federalist Congress passed a series of laws expanding the lower level federal courts and creating new courts and creating new justices or positions for justices. And when you do that, you're like, we created new courts. We need new justices. we're going to pack those courts with the Federalist justices, right? That the Federalist Party is still going to be really powerful because they're going to be in the federal judiciary. It'd be sort of like if Joe Biden runs for re-election in 2024 and he loses, but then let's say that the Congress is still in the hands of the Democrats and the presidency, right? That they're going to say, yeah, we may have lost the election, but we are going to expand the size of the Supreme Court and the federal courts. We're going to pack all those court judges' positions with Democrats, right? Well, Republicans would be pissed off, because they won election. So that's what happened in 1800, okay? And so that there were tons of new court justices positions that were created, and a lot of them were nominated by John Adams and then confirmed by the Federalist Senate. Well, most of those justices were seated on the court, but not all of them. There were 5 commissions that were never delivered to people who had been confirmed by the Senate. Because actually to be seated on the federal court, just getting confirmed by the Senate isn't enough. You actually have to receive your commissions. And William Marbury, seen here, he was one of the people who was confirmed by the Senate, but his commission was never delivered. He was pissed off because he never got his federal justice of the peace position. So you might be thinking, well, why didn't he get his commission? Well, there are 5 commissions that the Chief Justice of the Supreme Court at the time was John Marshall. He was appointed. He was a Federalist. He actually was a Secretary of State under Adams, but he's like, we want the Chief Justice to be a Federalist. Go be the new Chief Justice. And so John Marshall, rumor has it that he gave the commissions to his drunken cousin to deliver, and they never got it delivered. So when Thomas Jefferson and James Madison took over as president, took the office of the presidency, on their office desk were these commissions that had never been delivered. And Thomas Jefferson was like, there's no way I'm going to deliver these commissions to these Federalist judges. They didn't get these commissions delivered. I'm the president now, and my Secretary of State, James Madison, he ain't going to be delivering no commissions to Federalist judges. So he sat on the commissions. Well, that pissed William Marbury off, and justifiably so. He was supposed to be sitting on the federal court. So he was looking for a remedy. He's like, how do I fix this? So he looked through federal law, and there was this federal law called the Judiciary Act of 1789. And in that federal law, that federal law gave the power they created this new power for the Supreme Court. And it was known as power of writ of mandamus. And what that power is that it meant that Congress could force the president, or not Congress, the Supreme Court could issue a writ of mandamus to the President of the United States under this power that was established in the federal law of the Judiciary Act of 1789, forcing Thomas Jefferson to deliver those commissions. That's what a writ of mandamus is. It's like, hey, dude, you're not doing your job. We've issued a court order. Do your job. And so William Marbury said, look, I want the Supreme Court to issue this writ of mandamus, making Thomas Jefferson deliver my court commission so I can sit on the federal court. Well, John Marshall was between a rock and a hard place. He's basically like, if I force Thomas Jefferson to do something, he's not going to do it. And he's going to make the Supreme Court look weak. And so he came up, so he kind of came up with a solution to the problem. What he said you know what, William Marbury, you have been harmed and you deserve to sit on the Supreme Court. Unfortunately, the remedy is not forcing the Supreme Court to issue a writ of mandamus to Jefferson, telling him to do his job. Why? Because that provision of the Judiciary Act of 1789 right there that expands the power of the Supreme Court to issue writs of mandamus, that is a violation of the Constitution. Only the Constitution can tell us what the powers of the Supreme Court are. Congress cannot expand the powers of the Supreme Court. So he said, unfortunately, that clause in the Judiciary Act of 1789 is unconstitutional and it's invalidated. The court makes it null and void. In doing that, he created the power of judicial review. Basically said it's not in the Constitution, but it's implied. Because if laws violate the Constitution, as did the Judiciary Act of 1789, and they're still allowed to be on the books and the law of the land, it makes a mockery of the Constitution. And so that is how judicial review is established in the court case Marbury versus Madison. So Judicial review is established in Marbury versus Madison, and then it's employed in different ways into different categories of the acts of both of the federal government and the acts, laws, and practices of the states. And so you'll read more about this in your textbook, but judicial review can be applied to, obviously, the laws, the federal laws, as was the case in Marbury versus Madison. Here's a more contemporary example of that. And it's the case Citizens United versus Federal Elections Commission. You might be familiar with this case. This is the case that says that corporations have the right to spend money on political ads and political communications because that's their right under the First Amendment provision regarding freedom of speech. This case is about a federal law called the Bipartisan Campaign Reform Act. It was actually a bipartisan law that was brought to the floor of the Senate by Senator John McCain and the Wisconsin Senator Russ Feingold. It was known as the McCain-Feingold Law. And it wanted to get money out of politics. And so it put some restrictions on the kinds of spending that can be done for political campaigns. And one of the restrictions was that corporations could not spend an unlimited amount of money on political communications. And so Citizens United had made a movie about Hillary Clinton, and they wanted to play it right before the election. So in 2008, Hillary Clinton, was running against Barack Obama in the Democratic primary. And Citizens United was prohibited from running that movie because it violated the Bipartisan Campaign Reform Act. The question came to the Supreme Court, and they said that provision of the Bipartisan Campaign Reform Act was unconstitutional, that the law placing restrictions on corporate spending on political speech violated the First Amendment, so it exercised its judicial review by nullifying that part of the law, not the whole law, but just that part. That the judicial review can also be used to nullify the actions of the executive branch. The case Hamdi versus Rumsfeld, Don's Rumsfeld, this took place during the Iraq War in 2003. If you remember, after that, the Bush administration had a designation called enemy combatant, and these were people who are fighting as terrorists, either in Afghanistan or in, mostly in Afghanistan. And so this was an individual, Hamdi, who was fighting for the Taliban against the United States. He was found on the battlefield, and he was designated an enemy combatant, and he was denied, due process. He was denied a right to counsel and other, writs of habeas corpus. But Hamdi turns out he was a U.S. citizen. And so that the question was whether or not denying a U.S. citizen, even though they were designated as an enemy combatant, these fundamental rights, whether or not that violated the Constitution. And they said yes, that the executive branch denying Hamdi his right to counsel and his right to be told why he's being held was a violation of the Constitution, and therefore that law was nullified. That state laws, as we know, can be nullified by judicial review. Texas v. Johnson is a good example. We read about that earlier in the semester. That was the flag burning case. Texas had a law in its book saying that it was a crime to burn the flag. And Johnson said, nope, that state law is unconstitutional because it violates my freedom of speech. And the Supreme Court agreed. And so all of those are examples of the wide sort of birth of the power of judicial review as it relates to many acts of the government. So I know we just got done with the midterm exam, but you're going to have another exam coming up before you know it. And so on that exam will be a question where you get an opportunity to think critically about a judicial review. So keep some of these questions in mind. Do you think that unelected justices should have the power to overturn the actions of elected legislative officials, right? I mean, majority rules. Congress, passes federal laws basically saying, that those pass with the majority. State legislatures pass laws that, are a reflection of the will of the majority. Should 5 justices on the Supreme Court have the power to nullify the actions of a much larger elected branch, such as state legislatures and the Congress? Should the court defer to the legislatures, letting them resolve disputes in the law rather than exercising judicial review? What are some of the checks on the Supreme Court's power of judicial review? Are there adequate checks to prevent the Supreme Court from abusing its power? Because, they're unelected and they serve for a lifetime. They can nullify law. Are there any checks on the Supreme Court? And then think about what are the benefits of the Supreme Court exercising judicial review and what are some of the drawbacks. I know this lecture was a little bit longer than usual, but this is a lot of material to cover. So I hope that you learned something by listening to it. And thanks for paying attention, and I'll talk to you again soon.